So I have an important update for you on the emergency application, which is currently in front of the Supreme Court and is asking for them to step in and issue an injunction which would temporarily block the Illinois rifle and magazine ban. There's been a significant development in this case, so we need to talk about what's happening. But real quick before we jump into this video, if you think magazine and rifle bans are clearly unconstitutional, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they're huge SecMem supporters. They have dedicated roasts for organizations like GOA and FBC, so if you purchase those roasts, some of the proceeds go directly to those organizations so they can file 2A lawsuits. So again, check out Blackout Coffee using the links down below, and if you use the code ARMSCHOLAR, you can get 10% off of your order. As I mentioned in the intro, I have an important update for you on the current issues surrounding the state of Illinois rifle and magazine ban. An emergency application has been filed to the Supreme Court, and the Supreme Court has requested further briefing on whether they should step in right here and now and issue an emergency application, issue an emergency injunction, and halt this law from going into full force and effect. In the meantime, there were multiple cases also seeking intervention from the 7th Circuit en banc panel, including the case we're going to be talking about in this video, which is the NAGR versus Naperville case. Well, today we received notice from the 7th Circuit en banc panel that they denied en banc review in multiple cases which are challenging this law. In fact, not a single judge of the 7th Circuit en banc panel dissented or voted for review in any of these cases. This could further set the stage for some form of emergency intervention from the US Supreme Court, since the 7th Circuit en banc panel has denied review in all of these cases. Now, the case we're going to be talking about and focusing on in this video is NAGR versus the City of Naperville, and it's a challenge to a city ordinance which bans rifles in standard capacity magazines, but it's also a lawsuit which challenges the state of Illinois' PIC Act, or the Protect Illinois Communities Act, which also bans rifles and magazines. This case has once again been submitted to the Supreme Court for an emergency review. It's up on an emergency basis, and the Supreme Court has the ability to grant immediate emergency review on these issues if they want. The biggest concern right now is the looming registration deadline, which millions of people in Illinois are now facing, and the statistics are showing that very few number of people are actually complying with the registration deadline. So there is a lot at risk with this current review by the Supreme Court and the current emergency application that has been submitted to them. Now, for those not aware, this all involves an important challenge to the Illinois ban on so-called assault weapons and also magazines. In the NAGR case, the plaintiffs originally filed a motion for a preliminary injunction at the federal district court level. A preliminary injunction is a way to temporarily halt the enforcement of a law. The injunction remains in place until the case is resolved, and most often until the end of a trial. However, on review, that lower court, the federal district court, denied the plaintiffs NAGR their motion for a preliminary injunction. The plaintiffs then appealed that district court's denial, the denial of the injunction, up to the 7th Circuit and up to a 7th Circuit 3-judge panel. This is what's known as an interlocutory appeal. It is essentially an appeal on a motion being denied rather than an appeal on a final resolution of a case. It's an appeal on an in-between motion instead of an appeal on the final merits decision by a court. Now, after that original denial from the district court, this case then was appealed up to the 7th Circuit and it went in front of a 3-judge panel. Plaintiffs also filed for a motion for injunction pending appeal in the 7th Circuit, but the 7th Circuit 3-judge panel also denied that motion. Then the plaintiffs sought their first emergency application for Supreme Court review. What this means is that the plaintiffs, the NAGR plaintiffs here and the other plaintiffs in this case, wanted the Supreme Court to step in originally in this case and find that the district court and the 7th Circuit 3-judge panel should have granted the original request for preliminary injunctions in this case, and therefore they wanted the Supreme Court to issue that injunction on their own. Now, in response to that first emergency application, the Supreme Court denied review and they denied the emergency request for an injunction. The docket of the Supreme Court simply read that application for a writ of injunction pending appeal presented to Justice Barrett and by her referred to the court is denied. So the original emergency application was referred to the full court, and there were not even a single justice who at that time thought they needed to intervene and issue some sort of emergency relief. So the original emergency application was denied, and the case then proceeded forward in the 7th Circuit 3-judge panel level, and ultimately what ended up happening is that the 3-judge panel on review of this issue upheld the district court's decision to deny the preliminary injunction, which again wasn't shocking. And all of that leads us to the current status of this case and what we are dealing with here now in this case. NAGR then filed an appeal up to the 7th Circuit en banc panel. and they were asking for the Seventh Circuit en banc panel to review this case and review that denial of the injunction. But since there was that looming registration deadline and the fears that kind of attached to that and the unconstitutional basis of that registration deadline, the plaintiffs in this case, NAGR, also filed for a new emergency application to the Supreme Court, asking once again for the Supreme Court to intervene. But today, the Seventh Circuit denied en banc review in this case, and then also the Herrera, the Bevis, and the Anderson case, I believe. Not a single judge in the Seventh Circuit voted for en banc review, and there was not a single dissent informing us of why all these cases were denied en banc review. Once again, the Supreme Court is being asked to step in on an emergency basis to put a temporary halt on the Illinois PIC Act, and this emergency application is even more important now that the Seventh Circuit en banc panel is not taking review of any of these cases. Now, this NAGR emergency application was submitted to Justice Barrett, and she has requested that the city and the state of Illinois respond to the emergency application. Recently, the state of Illinois did file their response, and interestingly, one of the points that the response makes and one of the arguments that the state of Illinois makes was the fact that this case was still pending for en banc consideration in the Seventh Circuit at that time, and they were trying to use that as a shield of why the Supreme Court did not need to intervene in this case. Well, now all of that is off the table because the Seventh Circuit en banc panel has denied review. And because of that, today NAGR filed a letter to the Supreme Court notifying them of this fact. The letter of NAGR states that, "I am counsel of record for the applicants in the above captioned case. Applicants noted in their application that they have filed a petition for rehearing en banc in the United States Courts of Appeals for the Seventh Circuit. Earlier today, the Seventh Circuit entered the attached order denying that petition." And in this letter, they attached that notice from the Seventh Circuit. And that notice from the Seventh Circuit states that plaintiffs' appellants filed a petition for rehearing and rehearing en banc on November 13th, 2023. No judge in regular active service has requested a vote on the petition for rehearing en banc, and all members of the original panel have voted to deny panel rehearing. The petition for rehearing and rehearing en banc is therefore denied. So, in this NAGR emergency application, they have now notified the U.S. Supreme Court that the Seventh Circuit has denied their request for en banc review of this injunction and the injunction denial. Again, this further puts a lot of pressure on the Supreme Court because right now they're kind of the last line of defense because the Seventh Circuit en banc panel is not going to get involved. So this petition pushes for some really important questions that need to be answered by the U.S. Supreme Court, especially in light of what the Seventh Circuit has done in this case. NAGR argues in the emergency application that the Seventh Circuit completely just botched the Heller and Bruen analysis. They completely just didn't follow Supreme Court precedent, and they did that to ultimately meet their goal of upholding this rifle magazine ban. Now, I do want to state that the emergency applications and the intervention which is now being sought from the Supreme Court is rare. It's rarely ever granted. And the fact that the Supreme Court has denied intervention in this case and other cases before is not a great sign for what we're trying to get in this case. Also remember that most of these cases are on an interlocutory review basis. That means that there has not been a full final decision on any of these cases yet. The Supreme Court typically does not like to get involved in interlocutory appeals and on interlocutory basis. There is one full case petition right now that has been submitted to the Supreme Court, and that is the Colkins case. That is a state court challenge that went to the Illinois Supreme Court, and you may remember that I put up a video talking about how a lot of bias was found by the Illinois Supreme Court. Two of the judges there received millions and millions of dollars from the defendant, and so there was not only a challenge to the rifle magazine ban that's made its way to the Supreme Court, but there's also a question about bias and whether or not those two judges should have recused themselves. Now, that Colkins case, which again was the Illinois challenge, the state court challenge, that recently is set for Supreme Court conference on January 5th. But of course, that's not super helpful since the registration deadline hits on January 1st. My hope is that now multiple of these PIC Act cases, now that they've been denied Seventh Circuit en banc review, my hope is that all of these cases are then submitted to the Supreme Court for some sort of Supreme Court writ or emergency intervention, and maybe with 4 or 5 cases seeking Supreme Court intervention, that maybe could push the Supreme Court to see that, hey, this is a big issue. The Seventh Circuit is not dealing with this properly, and therefore we need to get involved. But in all reality, remember, the Supreme Court rarely does this, so I also want to temper everybody's expectations. But right now, we have to keep our fingers crossed and hope that something positive comes. But again, stay tuned to the channel because this is going to be very fluid and a lot of things could change rapidly. So make sure you're subscribed to the channel, have on all notifications so that you're updated if something happens. So if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.